At this juncture, I'm reminded of the explanation to Article 25, which deems Kirpans to be a part of Sikh religious practices. How is the hijab different in this context?
That's a very good question. First of all, explanation to Article 25 specifically states that Kirpan will be part of the Sikh religion. But it stops at that point. Now the explanation is not an exception to clause 2 of Article 25, which grants power to the government to regulate religious practices. So the wearing of kirpan or the carrying of kirpan can be regulated for secular activities and for social welfare and reform. So explanation merely says that the wearing of kirpan, the carrying of kirpans would be part of Sikh religion. Right. So therefore, it doesn't go beyond that. It doesn't say that students in a college or a school can freely carry kirpans. So it's only an explanation. So we cannot take the explanation beyond its contours and beyond its terms. So the hijab issue cannot seek any reliance on this explanation, and then there is no such explanation in favor of hijab. And this explanation was put into the constitution specifically keeping in mind that it may be a perception that kirpan is a kind of an arm. So to avoid that confusion, to bring in clarity that the wearing of kirpans is part of the Sikh religion. So that is the purpose of bringing in this explanation. In my view, this explanation does not have any impact on the hijab controversy. And tomorrow, if this question was to arise, where if some students go to the court that we want to wear the kirpan in a college, in the pre-university or in the schools, I'm sure, I'm quite sure the courts will not permit that, will not permit kirpans to enter the education sector in India.
How do you see the hijab issue faring in terms of the right to privacy argument?
Right to privacy has been recognized as a fundamental right, being part of the right to life, which is guaranteed under Article 21 of the Constitution of India. The right to privacy has been recognized by the Supreme Court in the Puttaswamy case. Now, my last book was on the right to privacy. So I have read Puttaswamy, line by line. Now, the right to privacy is not absolute, like other fundamental rights. It is not absolute in nature. There are exceptions, and those exceptions have been categorized as legitimate societal interests. So for legitimate societal interests, the right to privacy can be regulated, can be curbed. Now here, the legitimate societal interest would be that when students go to a school or college or the pre-university college in this case, in the hijab case, there has to be uniformity. There has to be discipline. So legitimate societal interest demands discipline, uniformity. And it is in this context that every student must wear the prescribed uniform. Right to privacy is not absolute. Right to privacy, cannot be taken to be some kind of a absolute freedom of choice to do what you want to. It is subject to legitimate state interests, legitimate societal interests. For example, security of the country is again a legitimate state interest for which the privacy of an individual can be intruded upon, can be regulated by the state. So therefore, the right to privacy will not apply in the hijab case.
How does it disturb the public order?
The Karnataka High Court has addressed this question, and see, public order is a general concept, and it is applied differently. It is defined differently in different contexts. Constitutionally, public order is very different, and when you have some of these other IPC and the other criminal statutes, the concept of public order is very different. So public order cannot be fossilized in a particular definition. It has no universal definition. Now, by public order, the Karnataka High Court means to say that the school or a college must have uniformity. There has to be homogeneity amongst the students. Suppose if every student is given the permission or the choice to wear anything he or she wants to, it will disturb the discipline of that educational institution. And the disturbance of that discipline is disturbance of public order. So it was in that context that public order has been used. It is not in the constitutional context, for example, clause 2 of Article 19, or from an IPC perspective. So public order has to be defined appropriately in the context of the issue, in the context of the situation, which has been done intelligibly by the Karnataka High Court.
And I think the court was looking into the aspect whether wearing a hijab or any extension of a cloth would create a sense of social separateness. That is where I think they were coming from.
Yes, I totally agree with you. Social separateness, accommodation, choice, they can't be blindly applied in every situation, in every sphere of the society. So, the Karnataka High Court has gone into how uniform in a school or a college has existed since time immemorial. And the High Court has gone into, case law from various jurisdictions, United States, etc., Australia, etc. And there has been a consistent view that in order to maintain discipline in a school, in order to maintain uniformity, in order to have fraternity, in order to have brotherhood in an educational institution, you need a uniform. So social separateness cannot be applied in the same spirit in an educational institution. Social separateness can apply in other social spheres. I repeat, for example, in a marketplace. For example, when I go to a restaurant in the evening. For example, if I go for a wedding ceremony in the evening, I go for a party to a pub or any other place. That is where I can exercise my choice as to social separateness, but not in an educational institution or the court of law.
And these days, even wedding ceremonies have a dress code, which we happily oblige to.
Yes, that's fine. But one can still exercise choice over there. But that's a private gathering. So, the host can actually refuse entry if you don't wear a particular dress code. But that will be in the domain of private law.
Right.
It will be more of the law of contract that will apply. If I am the host of a party, or if I am running a restaurant and somebody wants to have food in my restaurant, an implicit contract comes into existence. So therefore, I can impose a condition regarding some form of dress code. But that's in the realm of private law.